Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today is the day that we've all been waiting for. Since the new administration took office, the ATF decided to change their mind on pistol braces. Now we have the new rule that was just entered today into the Federal Registry. We have our very first lawsuit coming to you straight from the FPC. So let's talk about what's going on. So the case challenging the brace rule is Mock v. Garland, which was brought forward by the FPC. So the official names in this case are William T. Mock, Christopher Lewis, and the Firearms Policy Coalition versus Merrick Garland in his official capacity as the Attorney General of the United States Department of Justice, Stephen Dettelbach, in his official capacity as the Director of the Bureau of Alcohol, Tobacco, and Firearms, and the BATF itself. Now, I'll read directly from the filing here in just a minute if you guys want more information, but for now, let me just go ahead and give you guys a brief summary. So what Mr. Mock, Lewis, and the FPC are trying to do here in this challenge is basically vacate the ATF's rule altogether, which basically would make it disappear. It would mean that braces would no longer be considered something that they're not. They wouldn't convert something into something that they're not. It just wouldn't exist altogether. This new brace rule would be gone. So instead of just asking for an injunction, they're asking for a vacatur, a complete vacatur. Now, they do mention in here that if they can't get that, then the courts should at least enjoin this new rule, basically meaning that it wouldn't be enforceable until later discovery, or there'd be a ruling a little bit later on down the road, basically putting a pause, a hold, or a freeze on it. And they're stating that if the court does not do this, there's going to be serious harm to people's Second Amendment rights, and that it will infringe on their rights while this whole process is taking place. So while they're requesting that vacatur and have the thing completely gone, at least at minimum, an injunction on the enforcement of this law. So we'll start off here with the introduction. This lawsuit challenges inter alia the factoring criteria for firearms with attached stabilizing braces, Final Rule 88, Federal Register 6478, January 31st, 2023, promulgated by the Department of Justice, the DOJ, and the BATFE, collective agencies to regulate pistol braces as SBRs. In so doing, for the reasons set forth herein, the agencies violated the Administrative Procedures Act and the U.S. Constitution. So they're saying that it violates the APA and the Constitution. Number two, even if the final rule does not violate the APA and is allowed to stand, the agency's NFA laws, regulations, policies, and enforcement practices with respect to pistol braces that the agencies have classified as SBRs violate the Second Amendment. Plaintiffs thus further seek declaratory and injunctive relief to secure their constitutionally protected right to keep and bear arms in the absence of vacatur of the final rule. So again, even if they don't get vacatur, they want injunctive relief. Now, this was filed in the Northern District Court of Texas. Obviously, when you file a lawsuit like this, you want to do it somewhere that is friendly to your cause. And I think that in the Northern District of Texas, that's probably what they're going to get. So they filed this lawsuit. It challenges the new rule, and hopefully we can get a vacatur out of it. Obviously, if we don't, at minimum, we should get an injunction. The next section of this goes into how it's going to affect the plaintiffs, how it's going to make them criminals, how it violates their constitutional rights, and so forth, which basically is what's going to happen to all of us. So each time we talk about the plaintiffs and how it's going to affect the plaintiffs, we're really talking about how it's going to affect everybody that is affected by this new rule. So hopefully we get a judge that grants us the vacatur, or at minimum the injunction, and if it's somehow appealed, we end up winning that appeal. This is something that could take a long time. We know how these things go, but when you're talking about seeking some type of immediate relief like an injunction or a vacatur, these things can go a lot faster than the entirety of the case itself. Obviously, the case could go on for years and years and years, but as long as there is an injunction in place, then it wouldn't really matter how long it went on for. I believe that we will win in the end, regardless of appeal or what court it ends up in. But for now, we need to make sure that we at least stop enforcement of it, because there are just too many across the country. This affects too many people. It violates, in my mind, the takings clause, because you're something that you own and you're not able to use it anymore. I don't see that in here as far as the takings clause goes. I'm not a lawyer, but again, this, in my opinion, it does. And so I think that there's multiple ways to go after this. Hopefully there will be more lawsuits that will come forward as well, and we'll be able to put a stop to this new brace rule. So I will let you guys know if anything changes. Hopefully we see some good positive news here, and I'll be able to come to you guys with some more good news. But at least this is good news for now. Seeing lawsuits, seeing things come forward that are fighting for our rights, and the FBC fighting on our behalf, and the plaintiffs fighting on our behalf, that's something to give a thumbs up to. So I'm glad to see that. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.